You'll say when? Oh, we're ready? Good evening. My name is Linda Klein. I practice law at Baker Donaldson in Atlanta, Georgia, and I am privileged to serve this year as president of the American Bar Association. Welcome to this evening's public program for Law Day, and it's absolutely a pleasure for me to be here with you tonight. This year marks the 17th annual edition of the Leon Jaworski public program to commemorate Law Day. We're so pleased that Jones Day has graciously made this beautiful venue available to us, truly right in the heart of our nation's capital. I'm now delighted to introduce my friend, Stephanie Parker, a partner here at Jones Day, and Stephanie is the ABA's 2017 National Law Day Chair.
Thank you so much, and welcome to Jones Day. It's such an honor for us and a privilege for us to be able to host this year's celebration as part of the ABA's Committee on Public Education. Let me just take a moment and tell you a little bit about the history that I think you all will be interested in hearing. So you all have heard of Leon Jaworski, probably from Watergate. That's where I believe he's probably most famous. He was the second special prosecutor. He's the prosecutor who was appointed after the Saturday Night Massacre. But what's important for us and for today is that 2 years before his experience with Watergate, he was president of the American Bar Association. And one of the most important initiatives during his term as president was to establish the committee that later became the Committee on Public Education, which is in charge of Law Day. So through his great efforts with the American Bar Association and his personal philanthropy with the ABA, he established the lecture series that you all are going to hear this afternoon. So I'd like to just take a moment for all of us to thank Leon Jaworski and his family for everything they've done over all these years to support the program. So. Today is a very special day, not just here in the Jones Day Washington office, but across the United States. There are Law Day celebrations going on at courts and in schools and at local bar associations and at law firms all across the United States. And all of this has been led by the ABA and by the Committee on Public Education. And I want to take another minute and tell you a little bit about my friend Linda Klein here. So a number of us at Jones Day have known Linda for a while, especially those of us who are from Atlanta. We're very honored to be able to support not just the ABA, but in particular to support Linda and her year as president. Linda has made a number of very important changes and initiatives, and we're so proud of the work that she has done. So again, Jones Day is honored to be able to be here to support the ABA, but also to support Linda in her role. So thank you so much. We look forward to hearing the rest of the lecture. So.
Thank you so much. I told you she was my friend. Thank you so much, Stephanie. The ABA is again pleased to partner on this program with the Federation of State Humanities Councils and its president, Esther McIntosh. And in addition, we're pleased to partner this year with the National Constitution Center, and we're honored to have the center's president and CEO, Jeffrey Rosen, to serve as our program moderator. I'd like to begin with a few words on the topic for this evening. Law Day 2017 recognizes and honors the 14th Amendment to the Constitution. The 14th Amendment is one of the most complex and litigated of the constitutional amendments. It was passed by Congress in 1866 and ratified by the states in 1868 during the Reconstruction period following the Civil War. So we're commemorating the 150th anniversary between the 2 years, it's 150 years, of this transformative constitutional amendment. For this evening's Jaworski public program, we've taken as our title the 2017 Law Day theme, the 14th Amendment, Transforming American Democracy. But for this evening, we've added a question mark at the end. We do this as a way to investigate our theme to explore the 14th Amendment's significance, its purpose, its history, and its relevance. How, in fact, has the 14th Amendment transformed American democracy? When did it do so? And is it still doing so? We also know how the 14th Amendment provides constitutional guarantees of liberty, equality, and citizenship. Who are the key actors who have given meaning and force to the amendment's guarantees? And we'll explore what role the 14th Amendment plays in American law and life. And finally, what is its future? These are some of the thought-provoking questions we hope to consider this evening. So now to begin our panel discussion, I'm very pleased to introduce our program moderator, Jeffrey Rosen. He is the president and CEO of the National Constitution Center, and he's also a professor of law at George Washington University and a contributing editor to The Atlantic. An acclaimed author, his latest book, Louis D. Brandeis, American Prophet, was published in 2016. His essays and commentaries have appeared in The Atlantic, the New York Times Magazine, the New Republic, and the New Yorker, as well as on NPR. The Los Angeles Times called him the nation's most widely read and influential legal commentator. That's a big deal.
It was actually my mom.
Oh, apparently his mother writes for the New York Times, the Los Angeles Times. So I'm now delighted to turn the program over to Jeffrey Rosen.
Thank you so much. Thank you so much, Linda Klein, for your vision in choosing the 150th anniversary of the 14th Amendment as the theme for Law Day 2017. The National Constitution Center is honored to partner with you and the ABA to celebrate the anniversary of this most important amendment and of the three amendments which some have described as America's second founding, the 13th, 14th, and 15th Amendments to the Constitution, which turn 150 over this period of 5 years. Linda set out for us a phenomenal homework assignment to educate ourselves and you about how did the amendment transform American democracy? In other words, what was its original understanding? How did it achieve its purposes across history, and is it continuing to do so today? We have a dream team panel to discuss these crucial topics. I'm going to introduce them briefly, then we're going to read the text of the 14th Amendment, and we're going to jump right in. You have the program book, so I'll just introduce them in the most economical way possible. Laura Edwards is Peabody Family Professor of History at Duke. Roger Gregory is Chief Judge of the U.S. Court of Appeals for the Fourth Circuit. Daniel Ortiz is Michael and Jane Horvitz, Distinguished Professor of Law at UVA. And Michael Tiger is Emeritus Professor of Law at Duke University. Please join me in welcoming our incredibly distinguished panelists. Ladies and gentlemen, to kick off this important and exciting discussion, I'm going to put in a plug for the most exciting educational tool that the National Constitution Center has produced. And I want you to download it from the App Store. Not now because we're having a panel, but afterward. And when I tell you about it, I know you're going to want to download this incredible app called the Interactive Constitution. It has gotten 10 million hits since it launched a year ago. The College Board has made it the center of the new AP History and Government exams. And on this amazing and free nonpartisan tool, you can click any clause of the Constitution, including the 14th Amendment, and see the leading liberal and conservative scholars in America, nominated by the Federalist Society and the American Constitution Society, which are co-sponsoring this beautiful tool, with 1,000 words about what they agree the provision means, and then separate statements about what they disagree. And I teach constitutional law every day. I learn from this amazing tool, which there's so much to learn about each clause of the 14th Amendment. And here you can find Kenji Yoshina and phenomenal interlocutors. And I won't list all of them, but to see liberals and conservatives agreeing and disagreeing about this clause and all of our Constitution is just an amazing tool. So I know you will learn from it and enjoy it. Let me begin. In fact, so I need constitutional reading glasses, so I'm going to ask you to read the text of Section 1 of the 14th Amendment, and then we can get going.
You're assuming I don't need constitutional reading glasses.
Absolutely.
Okay, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws.
That was beautifully read. Thank you so much for that incredible reading of the Equal Protection Clause from the thrilling interactive Constitution of the National Constitution Center. Now, Laura, you selected a really beautiful and rich passage from our reading. The audience can find it on page 10. And this is just an amazing compendium of quotations that our panelists have selected and that Howard Kaplan, the incredibly visionary producer of this program who's done so much to educate Americans, has also helped produce. So I won't, Laura, ask you to read all of the statement by the Tennessee Freedman to the Freedmen's Bureau assistant on July 27, 1865, but I want to begin with the original understanding of the 14th Amendment. What was it trying to achieve, and what can this incredibly rich passage tell us about what the freedmen thought that the 14th Amendment was trying to achieve?
So these people are former slaves, and they're writing from Lincoln County, Tennessee, which I think is deeply ironic. Lincoln County, Abraham Lincoln, apparently, though, this is not Abraham Lincoln. This is Lincoln, who was a Revolutionary general. Nonetheless, they're writing from Lincoln County. The metaphor's great. And they're saying, look, our state of Tennessee, which was a slave state, it is now being readmitted to the Union in 1865, and it has, as part of being readmitted, outlawed slavery. And yet, what the state constitution does is it still holds in place all of the restrictions on African Americans on the basis of race, restricting rights on the basis of race to all now free African Americans. So they've extended the restrictions on free people of color basically to now all free African Americans. And so these people are writing from Lincoln County, and they're saying, wait, hold on. We are, in fact, citizens of the United States, which is not entirely clear, in fact, at this point. And we need these laws to be extended to us so that we can act as free men, and they're all men, and they're talking about, free men in our state. They are very aware of the Constitution of their state, the ways that limit them. They're also appealing now to the federal government to come in and help them. They said, we have no alternative. The power of this state is such that there is nowhere to appeal but to the federal government. They know how these jurisdictions work, and they want to be able to appeal to the federal government. What they want is a 14th Amendment, essentially. They want to be able to access the power of the federal government to come in and then question the inegalitarian laws in their state. Now, there are two really interesting things here. One is this is 1865. This is before, actually, the 13th Amendment has even been ratified nationally. This is way before the 14th Amendment. And yet, these people in Tennessee are very much part of a larger legal debate that is widespread in the United States in the first half of the 19th century, where people are questioning the ways that states can restrict the rights of some people in some places, but not in others, where there is also a wider debate about perhaps having a federal standard for rights to apply to all citizens. And they're also appealing to federal authority to step in over state authority, which really changes federalism in the United States. And these are people in the middle of Tennessee, literally in the middle of Tennessee, who have been former slaves who are keyed into this debate. So I think this really changes our understanding of the broader historical context of the 14th Amendment in some key ways. And one is, we usually think of the 14th Amendment as something that guys in Congress passed. Actually, white guys in Congress passed. And in fact, while the 14th Amendment was framed by those people, it was done in a context where there was a much wider discussion about these issues that included a broad range of people, not only African Americans free and enslaved, but also women as well, poor people. People had different ideas about what the federal government should be doing, what rights should look like, and how they could access government power. And so the 14th Amendment, I think, needs to be understood in that context, one that is a legal heritage that is shared by all Americans more broadly, not just something that has been handed to them from above by lawmakers in Washington. And I think that complicates it another way because this reads conflict into the 14th Amendment. Freed people in Tennessee have a very different idea about what their rights are than lawmakers in Washington, even the most sympathetic white lawmakers in Washington. So at the heart of the 14th Amendment is also a wider debate about the purpose of government, how we access government power, and what rights are. And the 14th Amendment opens up that debate. Some have seen this as a negative conflict, but that conflict is actually a discussion about the fundamental purpose and principle of government in the United States. And the 14th Amendment really does this in a new and profound way that actually allows even more people into this discussion than before.
That is a wonderful way to begin. And you have taught us that even after emancipation, there was a vigorous debate about what rights should be protected as the basic rights of citizenship, who should protect them, the federal or the state governments or the courts, and who should define those rights, the people or the legislators. Chief Judge Gregory, you have selected the passage by Fred Vinson, which appears on page 11, and right before that is the text of the Civil Rights Act of 1866. So chronologically, this works really well because, as many of us may remember from law school, the 13th Amendment is passed. The southern states passed the black codes denying the freedmen the basic rights that Laura talked about, including the right to make and enforce contracts, to sue and be sued, to inherit property. Congress passes the Civil Rights Act of 1866, setting out these basic private law rights that everyone agreed were the basic rights of citizenship. But President Johnson vetoes the act, and there's doubt about Congress's constitutional authority to pass it, which is why many of the Reconstruction Republicans consider Section 5 of the 14th Amendment, which explicitly gives Congress the power to protect the rights enumerated in the Civil Rights Act, the most important of the bunch. Chief Judge Gregory, tell us, why did you select this completely fascinating passage from Shelley v. Kramer? Who knew that that Fred Vinson, Chief Justice Vinson, would write such an expansive and pro-equality opinion, and what does it tell you about the core original meaning of the 14th Amendment?
Well, I chose it because it showed how over time we had to, when we mean of a nation in terms of constitutional jurisprudence, had to overcome a very big hurdle of those cases I'm sure we're going to talk about later in terms about what was required. State action was required that was prevented by denial of equal protection. It had to be state action. If it was an individual, and we talk about some of the cases of the civil rights cases of 1883, they were just horrible in terms of, and I will hope later we'll talk about Justice Bradley's opinion, but if there wasn't state action, the 14th Amendment did not prevent it, therefore provided no protection against equal protection. Here what we have is this. Normally, we're in the South, where you have what's called restrictive covenants. I build my home, I own it. In my original documents in the title, I say this: no one other than persons of the Caucasian race will ever live in this place, own it, lease it, or have anything to do in terms of ownership. Private agreements. Normally, it's insulated from state action. But this case was seismic in terms of just, it pushed way over the top the whole idea, the view of this is that. No, courts have to enforce this restrictive covenant. Because, for example, if someone sells it or leases it to an African American, if you want them to be evicted, to get in terms of get quiet enjoyment or regain it, you have to go to the courts. And what Justice Brinson, Chief Justice, is saying here in terms of the 14th Amendment, no, these are not just private contracts. You are enforcing a law that takes away the very idea of enjoying property and using the court to sanction it. And another personal reason is this. I must say in 1981, my wife and I had been married a couple of years where she was with child of our first child, and we purchased our first home, and the house closed, and I happened to be looking through the deeds. This is Richmond, Virginia, and I looked at the old restrictive covenants, and it was almost a cruel part of history because I saw the restrictive covenants like no fence can be in the front yard and it had to be 2 stories, but there, rather than obliterating the restrictive covenant, the one provision, it was just a line, and it said, this property should never be owned or possessed by anybody other than a Caucasian race. Here I am, a lawyer with a family and all of those things. And I thought about that. Of all of those things and attributes I had, I could not overcome the test. And that was my color. And I thought about that and how the 14th Amendment gave breath and life to real life experience of seeing that. So those words are not just hollow words, but they're real words in heaven. Look through that, and I think about those people who never had a chance, even if they could afford it, to live in that home, to own it. But that's an important case because it did reach that private agreement because state courts enforced it, and that was state action. That was powerful, very seismic in terms of growing democracy, and those truths now we're beginning to hold as self-evident.
What a dramatic example of the actual effect of the amendment and the necessity of court opinions to make its promise a reality. Michael, you selected the provision about one man, one vote. I'm going to ask you about that later because, Daniel, sorry, let's keep going in order. I want to stay with the original understanding. You've written so much about the original understanding of the 14th Amendment, Daniel Ortiz, and tell us what you've heard from your previous panelists about what the original meaning was. And there's a big debate today about whether the amendment was intended to require government to be colorblind under all circumstances. You've written a lot about that question. As an original matter, did the framers of the 14th Amendment intend that government be colorblind in all circumstances or only in some?
Well, the narrowest form of the original understanding doesn't really favor the colorblindness view much at all. I mean, at the time that the framers were writing the 14th Amendment, they were setting up the Freedmen's Bureaus and other things like that, which were basically meant to help one racial class that had been historically oppressed. So in that sense, there's not very much evidence there. What's wonderful and also frightening about the 14th Amendment, though, is what kind of purchase the narrow original understanding should have on us now. The original understanding of the 14th Amendment probably also in its narrowest forms didn't prohibit segregated schools. So it sort of works in both directions. We tend now to celebrate Brown as the one thing that everyone agrees that the Supreme Court has gotten right, and it tells us great things about ourselves and what we value. But at the same time, we tend to criticize other kinds of things that move away from the original understanding. But that's the nature of interpreting the 14th Amendment, and I think those debates will always be with us and will always be deeply political. And they not only tell us much about the original understanding of the 14th Amendment and who America was then, but also who we are now. How we actually engage in these debates and settle these disputes.
That is a very powerful reminder that the original understanding of the amendment may not cover Brown. I had a remarkable experience. I had an opportunity to have dinner with the late Justice Scalia right before he passed away. And I was in a bold mood, and he was being incredibly charming and very voluble and funny, and I think I'd had a glass of wine, and I said, Justice Scalia, you know, a lot of scholars say Brown is impossible to reconcile with the original understanding of the 14th Amendment. What do you say to that? He paused for a moment and thought, and threw back his head and said, you know what? No theory is perfect. A wonderfully candid response. Michael Tiger, you chose some really powerful passages, including with an evil eye and an unequal hand from the Yickwo and Hopkins. We're in 1886 here, and I do want to stay in this first round on the original understanding of the amendment. What does the Yickwo case, why did you choose it, and what does that say about the extension of due process and equal protection rights, not just to citizens, which the Privileges or Immunities Clause limits its reach to, but to all persons, citizens and aliens alike?
Well, Yickwo is a good case because it's virtually the only case in the first 40 years of the 14th Amendment in which the court took equal protection seriously. They were all fine on due process as long as it was protecting the rights of the wealthy, but equal protection, not so much. That gave us Plessy versus Ferguson, the so-called separate but equal doctrine. So Yickwo was great because here is an analysis that says, here's a statute in San Francisco, a municipal ordinance that said you can't have a wooden laundry. Then you go down the street, Leavenworth Street, and you see, gee, the wooden laundries are owned by Chinese people. And the laundries that aren't wooden laundries are owned by people that are not Chinese. Something must be wrong here. So the court looks behind the ostensible claimed neutrality and gets to the heart of the matter. That's the first, that it seems to me is the enduring lesson of Yickwo versus Hopkins. We can get in later to this notion of personhood, which is what the court wrestles with also in that context. But I gather that you'd like to stay for now in the 19th century, which for a guy my age is just fine.
Well, you've done so much to bring the amendment into the 20th century and the 21st, and that's the subject of our next round. I think I'm going to begin by asking you, Laura Edwards, if you had to pick a single case that fulfilled the 14th Amendment's promise and transformed American democracy in the 20th century, what would it be? And just to make things interesting, let's leave out Brown, granting that that may have been the most important. But aside from Brown, which case would you pick and why?
So actually, can I haul you back a little bit to the 19th century?
We can stay as long in the 19th century as you
Okay,
like.
great.
It's a good place to be.
As a historian, I do 19th century history. I am most comfortable there. But
Good.
I also find that there are pieces of the 19th century that are really important to know in order to kind of frame the way that we're thinking about rights today. And so actually, to pull us back for just a second before we go to the 20th century, one of the things that I find most interesting is the difference between the 1866 Civil Rights Act and then the 1875 Civil Rights Act, which are all both in here if you want to follow along in your program. But the 1866 Civil Rights Act lists out a very narrow band of rights, primarily rights to access the courts, primarily rights to own property, and they also mention the punishments, that you can't use different punishments. You can't be tried criminally under different kinds of laws that then have higher punishments for the same crime for some than others. So it's a very narrow band of rights, actually. And you often find this in the 19th century, where people are talking about rights in a rather, narrow way. It's not this expansive thing. Again, when I walk into class, in my US history class and my US legal history class, students will think about civil rights, and they see everything as a civil right. So civil rights, essentially, things that I want to see happen, and that would be a civil right. But in the 19th century, it's really not. People are thinking very narrowly. And here is what I think is so fascinating about the 14th Amendment, because it opens up this larger debate about what a right is. So in 1875, when you have the Civil Rights Act, you see there that people are talking about access to public accommodations, something that, in fact, in 1866 in the Civil Rights Act, it's not there. That's not, people are not thinking civil rights necessarily in those terms. 1875, that has already come in, and people have been on the ground trying very hard to push those particular privileges as civil rights. Right out here in front of the Capitol, African Americans were demanding access to public transport, local public transport, public accommodations, actually public schooling as well. All of those things on the ground were being pushed politically. You see that then move into people's conceptions of what civil rights are in law. And so I think it's fascinating then, actually, not a particular case, but in the context of the 20th century and 21st century, where civil rights becomes so expansive that we now use this as a way to talk about all sorts of things we consider as public good. And that isn't necessarily the language of the 19th century. And so to me, at least, that's an incredible transformation, and one that we could really miss without that kind of historical context.
I'm so glad that you focused us on the 1875 Act and kept us in the 19th century, because that also reminds us that the Supreme Court struck down the Civil Rights Act of 1875 in the civil rights cases.
And yet all those things that are listed in the 1875 Civil Rights Act, most of us would now agree those are civil rights.
Absolutely, and that amazing story of Justice Harlan's dissent, where he had a writer's block, and then suddenly he found the language flowing because his wife had found the pen that Chief Justice Taney wrote the Dred Scott decision with and put it on his writing desk, and he was seized with inspiration, and the dissent flowed, and he predicted that one day this shameful decision would be overturned, and indeed it was in the Civil Rights Act of 1964, which was upheld by the court. So, Chief Judge Gregory, that reminds us that the Supreme Court really was not a friend to civil rights in the late 19th century, and in the civil rights cases and the slaughterhouse cases and the series of cases, it thwarted the promise of the 14th Amendment. Where in the story do you want to pick up, and at what point did the Supreme Court start becoming more enlightened, and why? And of course, if you want to talk about Brown, you can, but just if you can tease out how it was that you picked Fred Vinson, who voted on the other side in Brown initially. There's that wonderful story of how the court votes in Brown to uphold segregation. Chief Judge Vinson unexpectedly dies on the train on the way home. Felix Frankfurter says, "This is the first indication I've ever had that there is a God," which was not a nice thing to say. And then Earl Warren is appointed, and Brown comes out the other way. But we have a lot of history. What do you want to tell us about why the court changed its mind in Brown, and what the most important cases of the 20th century was?
Well, it changed its mind. I think that the power of an ideal is so powerful. And I think what the 14th Amendment did right at the onset, it said every person born, person. And it did not, although clearly the Congress was targeting in terms of trying to remedy what was happening to the freedmen, what had happened to the enslavement period. But every person, for an African American, for the first time, you were a person. You were recognized as a citizen. And even though there would be a long haul, as you said, maybe over 100 years later that it came into full fruition. But I think that the whole idea that there must be something important about being a national citizen, and the court recognized that of all the conventions of constitutional federalism and all of those restraints, it has to mean something to be a United States citizen beyond just a state citizen. So I would pick Gideon v. Wainwright. In Gideon is a case a man was accused of breaking into a pool room, B&E, and he was charged, of course, with the felony crime down in Florida, and he was indigent. So he asked the court for an appointment of a lawyer. And under Florida law, there was no requirement that the state of Florida had to appoint a lawyer unless it was a capital case. And fortunately for him, this was not a capital offense for breaking and entering, but he went to trial, he was convicted, and he went up through the processes of the highest court in Florida, and it got to the Supreme Court. And for his writ, which means basically the request for the court to hear it, he wrote it himself in pencil. So powerful an idea in terms of time, and the time is always right for now. And then the whole idea is that the Fourth Amendment protected and incorporated the rights of the Sixth Amendment right to counsel. It was incorporated in terms of due process of law, and states don't have the option to say, no, we're going to try you. And I think about the black codes. The black codes, Mississippi, I think, and maybe Georgia is one of the first states to have them. One of the states had a code that said this: if you were charged with a crime and you couldn't pay the fine, can you imagine this? After 5 days, anyone could walk up and say, hey, I'll pay that fine. They would pay your fine, and you, the prisoner, would have to work for that person until you paid off the fine. It was nothing but second-class slavery. Basically, man, and so they determined what the wage time is. So if it's a $10 fine, and that's a lot of money, suppose your pay is $50 a day, 50 cents a day. That takes 20 days of what? Picking cotton, pulling tobacco, whatever the servitude was. And so beginning to say, no, you're going to have a council. That was important and incredible. The 14th Amendment opened incredible doors. And just think now how many people in terms of innocent projects, we find out now they're innocent. Can you imagine going before felonies without counsel? I thought, Jeffrey, that was powerful in terms of Fourth Amendment's impact.
Those are amazing examples. I'm glad I asked. Gideon is a just incredibly dramatic case, and to see those peonage laws that the, Chief Judge Gregory just referred to, the new African American Museum, which I just had the privilege of seeing, is absolutely riveting. It's just such an extraordinary job, and they have the bills that allowed people to basically put people in peonage in the way that...
May I add something to that?
Sure.
Because it seems to me that there are two wake-up calls we could look at. One is the case of Sweat versus Painter, which was 4 years before Brown. The University of Texas, Heyman Sweat applied to the law school, and they said, well, you're black, you can't go. So they established an equal law school in 2 rooms downtown Austin with no law review, no moot court, no order of the coif, and so on, and said, this is the equal law school, the Texas Law School for Negroes. And Charles McCormick, Dean McCormick had evidence, swore under oath that you didn't need a law review, didn't need order of the coif, didn't need any of that. Those are irrelevant. And this law school was in every respect equal. The state of Texas quoted the former president of Harvard saying that integration in public education might require 500 or 1,000 years, because after all, it's only recently that African Americans came to the United States where they would learn about our civilization. You can pause to consider that. These are briefs, the Supreme Court of the United States. And the Supreme Court basically said, are you kidding us? Do not on my boots and tell me this is a rainstorm. But you read these briefs and you realize that's got to be the wake-up call in which the court says, I'm sorry, this is an elaborate pretense, a mythology to maintain a system that everybody knows, except counsel for the state of Texas, who later became Chief Justice of its Supreme Court, is racist. That was wake-up call number one. The second, which we may get to, I think, is the sit-in movement, which brought direct action into the fore. But Sweat versus Painter, S-W-E-A-T-T, you can look it up on Wikipedia for all the non-lawyers in the audience. That's a great introduction.
Amazing example, and that everyone knows language was what Justice Harlan himself had used in his Plessy dissent, saying everyone knows what the real purpose of segregation was, but it took the court until Sweat, you remind us, to recognize that in the majority. Daniel, you do cite the one-man, one-vote case as one of the most important. You talk about that or any other that you think is most important?
Yeah, no, I'm an election lawyer, so this one was easy for me. We tend to think of the 14th Amendment's great victories and actually great mistakes in terms of protecting minorities from majoritarian political process. Cases like Brown versus Board of Education, or the VMI case where the Supreme Court said that women had to be admitted to the Virginia Military Academy. Even cases like Gideon, Moran that can be viewed in that way. We tend to view some of the great mistakes now as also protecting minorities from the majoritarian political process. Cases like Lochner, where the Supreme Court struck down New York's maximum hour minimum wage laws under a theory of freedom of contract, that somehow such laws denied due process to individual workers and employers in negotiating what hours people wanted and could work. And there are other examples of that too. There's a whole other side to the 14th Amendment, which I think is just as important, that we tend not to think about, which is not protecting minorities against majorities, but protecting majorities from some, not minorities as we tend to think of minorities now, racial minorities, sexual minorities, things like that, but political minorities. And another purpose of the 14th Amendment is to make sure that the political process can run clear in just majoritarian terms. So for example, most famously in the one-person, one-vote cases, the courts forced state legislatures across large parts of the country to reapportion themselves so that rural interest didn't have much more weight in state legislatures than urban interests did. What happened was many parts of the country enacted new constitutions in the early 20th century, which required reapportionment after every decennial census. But somehow they just never got around to it. And so you still had the same legislative lines in the 1960s that you had in the 19-teens. And of course, there had been a lot of migration away from rural areas into cities. It was completely unfair and undemocratic. But it's not clear where in the Constitution you go to get that fixed, if you will. And it took the court a series of years. First, they had to say that we can just look at these kinds of questions because they're not inherently political. And then they had to bite the bullet and figure out what the actual rule was. Came under a lot of criticism. It was very difficult for them. They eventually came down with the one-person, one-vote rule. People said, this is outrageous. And you know, about 3 years later, the whole thing went away. No one cared. Everyone sort of thought it was the right thing to do. But I think in our rightful focus on protecting minorities, we tend to just forget about that other side of it, which I think is just as important.
Hugely important, and perhaps sets up the last round that we're going to have before opening up to questions. And this is the way I'll pose the question, Laura. There are some scholars and public officials, including former President Obama, who said that the greatest advances for civil rights in the 20th century and the 21st came not from the courts, but from political activism, from the ground up. And David Cole, the new legal director of the ACLU, has just a fascinating new book out saying that the major movements of the 20th century, including reproductive choice, marriage equality, and Second Amendment rights, all of these 14th Amendment questions, all were the result of political activism that was later codified by the court. Laura, do you agree or disagree, or do you want to amend it? Who was more important in achieving the promise of the 14th Amendment, political activism or the courts?
Well, it's got to be a dialogue, right? I mean, if you look at the period, the post-Civil War era, opening up a broader conversation about what rights are, who should be enforcing them, how people have access to government. You've opened up a law has opened up a conversation about that and given people access to courts in new ways, and especially access to federal authority. So it is always a dialogue, I think. It's because the 14th Amendment opens up these possibilities for people to raise issues and to have the federal government step in and actually be an authority over states, where the states used to be the end game. If you didn't get what you want through state government, well, it's just too bad. You're just going to have to move to another state or whatever. But there was no other place to appeal. And now there is. And so people, I think, then start trying to do that. They find ways to, now new ways to bring their ideas about what rights are and change the law. So it is, I think, a dialogue. That would not be possible without the 14th Amendment. But also our current interpretation of the 14th Amendment of rights would not be possible without what people are doing on the ground as well. So I think both of those things are important. And I think it's also important to realize that political activism in and of itself doesn't necessarily lead in a particular legal direction either, right? So for instance, one thing we haven't talked about here is women. And the people, the persons who are protected in the 14th Amendment, women have always had a very difficult relationship to the 14th Amendment, and particularly until the mid-20th century, in fact. So a legal person is not necessarily the same thing as we think out there as an actual person, right? So women have been trying to include themselves within the 14th Amendment as legal persons at a very difficult time because states had all sorts of laws that restricted women's rights when they were married. The status of women made it very difficult for them to access these privileges in the 14th Amendment, through the 14th Amendment, that men could. And so there is, in fact, another set of legal framings that also directs political action in certain ways. So you may want to claim certain rights, but in fact, laws on the ground and the way the law is framed is going to direct you in certain ways. It made it very difficult for women, as opposed to men, to claim rights under the 14th Amendment. That too is a legal framework, and it also then frames the way that political action can move, I think.
That's a very powerful example of the dialogue between the courts and the political system, and women is the perfect example. Of course, when Justice Ginsburg argued her famous cases in the 1970s, she was working off of the social changes of the women's rights movement, but also helping courts codify it. Judge, you alone on this panel can give us insight about how judges interact with the broad changes in society. And we're often told that the courts don't follow the election returns, but again, Justice Ginsburg had said that courts may pay attention to not the passions of the moment, but the deep sentiments of the hour. We have a bunch of quotations from the marriage equality cases where the court, social views seem to shift so quickly and the courts seem to codify it. Using that or any other example, what insight can you tell us about how the courts pay attention or not to social change?
Well, we're the only branch of government when we take an oath to office that all of us swear to protect the Constitution and those things. But we're the only ones that take an oath to be impartial. The legislative branch and the executive branch, anything but impartial. People elect them to be very partial to their view. But obviously, we're part of the, as they say, we run our stick along the public rail like everyone else. We see what goes on. We understand the hue and cry and those people in terms of the difficulty, as Laura said, in terms of women, although persons stated, it was a long time before recognizing it was because of the international suffrage movement, and that movement certainly had a big part. So yes, it does influence and brings along. As a matter of fact, we're the passive branch of government. You have to bring something to us. We could sit around and see all types of wrongs pass us by, and we could do nothing because we can't cherry pick the time or the place to correct. So someone comes to us, and the fact that it comes to us, it's already been this groundswell of advocacy, of recognition. For example, harking back just to the walls that tore down Sweat and McLaurin and all those cases, Murray, Scipio that came through. Well, unbeknownst to the public, Justice Brandeis was a very good friend of Mordecai Johnson, who was president of Howard University. And in 1926, he told him, listen, if you're ever going to do something about this situation of discrimination and the treatment of African Americans, you're going to have to train very well your own African American lawyers. That was the start of the whole idea of Howard's law school in terms of the law school didn't begin there, but it ended the Ninth Division, and it brought on Hastings and Thurgood Marshall and all these people in the class who just brought it. So advocacy and politically and otherwise, certainly they bring these great causes to the courts, and the court has a chance to impartially, with clearer thinking over time, make those changes, but still speak incremental to the promise of a constitution, because after all, we're expounding on a constitution, not a statute, but a constitution which has common law notions and all those ideas of constitutional text and context. But certainly it is that movement of advocacy and political movements that really made the difference, I think, in the new breath and the new birth that on paper the 14th Amendment did, that now we can enjoy a lot of broader inclusion of what American democracy is.
I'm so glad you told that story of Justice Brandeis. Linda mentioned my book on Brandeis, where I also tell that story. And although Brandeis did not have a great record on race, he wasn't bad, he was sort of silent, he was AWOL. Right. His Brandeis brief, which emphasized the importance of facts, did inspire both Mordecai Kaplan, also Thurgood Marshall when he wrote his Brown brief, and Justice Ginsburg, she told me, when she wrote her great briefs about gender equality, reminding us of the importance of facts and that kind of activism and ultimately shaping the courts. That's a great example.
Could I add something about facts? Because, you know, we lawyers, our egos make us think we stand at the center of all the events by which the world has moved. And I think it's time to recognize that when we can stand only because some client has been willing to come forward, as with so many African-American families in the South, and say, yes, I'm a victim. I will stand up to the public obloquy, to the threats and so on, if you, the lawyer, will take my case. And so I think we need to give a shout out to the very brave clients, including the fellow that wrote his cert petition on a pencil on a bag and sent, because without their courage and without our effort then to understand their goals, we wouldn't get very far.
Very powerful example. And you have been called one of the most influential lawyers of the 20th century in actually arguing these cases. You know how important facts are, and you have helped to shape the meaning.
Well, somebody once asked me, are you a cause lawyer? And I said, no, I'm a client lawyer. For what it is worth.
Just because, and Daniel's going to have the last word in this round, but what was your favorite of your own cases, 14th Amendment cases? What was the most important?
Oh, gracious. Well, you know, my favorite is just a little district court case desegregating the country club out in Kenwood in the suburbs of Washington, D.C., where Barry Goldwater got thrown off the golf course. He said, I've only played 9 holes, I'm only half Jewish. And Carl Rowan was denied the right to go speak at a dinner that was there. So we got a group of people together and sued, invoking the state action doctrine because they had a bunch of tax benefits. And I mean, there are a lot of dramatic cases and this, that, but to meet with that community and those folks and say, you know, let's just change the way we do stuff in this town. I enjoyed that. I mean, it kind of, here I am in Washington, D.C., and a lot of people thinking, gee, we got to change the way we do stuff in this town. So, you know, that's my favorite.
That's great. I'm glad I asked. Daniel, last word to you before audience questions. You can sum up this amazing discussion as you like, but my question to you is, on balance, have courts been friends or enemies of the 14th Amendment's promise of equality for much of the 20th century?
Depends on the time and who you consider your friends and your enemies. Right? It's certainly the court hasn't been what we now view as uniformly progressive. It's even from just a progressive perspective, it's taken some steps forward, sometimes taken some steps back, sometimes more steps back than it did take forward. For a long part of the last century, early 20th century, this court, as in Lochner, was saying that the state couldn't get involved in regulating the market. Well, of course, that helped the people who were powerful within the market and hurt people who weren't powerful in ordinary economic terms in the market. Later, in the mid-century, it took racial equality much more seriously. Later still, it took sexual equality much more seriously. First gender equality, and then at the beginning of this, and more recently in this century, marriage equality. Now, from a progressive perspective, that switch has been very good. From someone who is a more traditional property type libertarian conservative, probably anathema, right? Lochner, you know, preventing the state from regulating the market, that's where the action should be, not protecting these classes of people against certain forms of discrimination. That's less important. So it depends, where you're coming from, where you're going. But I think, to most people, the court made a change probably around the end of the first third of the 20th century, and we've seen a lot of progress. It's not been uniform since then. And there's been a lot of argument on the court trying to cut back at times on what the promise of the Warren Court, for example.
An excellent reminder that these debates remain live and highly contested. We have, ladies and gentlemen, about 10 minutes for questions from this amazing panel, so let's take them. Yes, sir.
Will the 14th Amendment transform world governments? Are the ideas of privileges or immunities and due process and equal protection showing up in governments around the world?
Well, before I turn that over to our panel, I'm going to refer you to the thrilling interactive Constitution, because in addition to having the top liberal and conservative scholars debating every clause, there's an amazing feature where you can click on any part of the Bill of Rights and compare it to constitutions around the world. So it's just so cool. So you can click on the Fourth Amendment, for example, and see all the countries that have Fourth Amendments, and see that when General MacArthur wrote the Japanese Constitution, he cut and pasted the American Fourth Amendment. So the language is exactly the same, whereas the Russian Fourth Amendment looks nothing like ours, in the Russian Fourth Amendment. Anyway, we can look at privileges or immunities and actually trace the textual similarities, but it's a deep and important question about how much American notions of privileges or immunities in particular, and you might add due process and equal protection, have influenced other constitutions. Anyone want to
Well, I'll talk. I mean, it's clear to me, we met through the ABA, a bunch of lawyers in the former Soviet republics and so on, and they were drafting new constitutions. And they all wanted to look to what they thought was the best part of what we were doing. I worked with the ANC in drafting the South African Constitution after Mandela got out, again, looking to the American Constitution. But more significantly, in 1900, the Supreme Court decided a case called the Paquete Habana, holding that customary international law was a part of the Constitution, laws, and treaties of the United States. So to the extent that our law, our ideas, become accepted and read and acted upon in the international community, they become part of customary international law. That being a theory about the formation of international law that Chief Justice Marshall wrote about in a decision called the Antelope. Now, he got it completely wrong on the merits, because he said, well, as long as the Spanish and Portuguese have slavery, I guess it's okay. But the dominant 19th century notion was that we were a nation among many nations, and that just as we could learn from others, others would learn from us in the community of nation states. So for me, the answer is, yeah, it could help.
And just because this is so interesting, and the 14th Amendment was passed at a time when the American ideas were being exported and other countries paid attention to it?
Oh, yes, indeed.
Yeah. Great. Yes, sir.
Paul Friedman. The will of the majority in our nation seems to be stymied by gerrymandering today. I live in Virginia. We have 32 Democrats in the General Assembly, in the House of Delegates, and yet we win generally by a point or two or more statewide. Democrats win, we control all 5 statewide seats. There's something inherently wrong in our system, and there's a growing hue and cry that our system is just failing us based upon the Constitution. Is there a chance that our courts will ultimately reinterpret the gerrymandering under the 14th Amendment and find a new way for us to elect our legislators so we can have a system that fairly reflects the views and the values of our country?
Daniel Ortiz, you are election expert as well, and you can tell us, if you would, about this fascinating case bubbling up in the appellate courts where a majority of voters claim to have been denied a majority of seats because of gerrymandering, and might that go up to the court, and how might the court rule?
Yeah, the case to watch is one coming from Wisconsin, and it's clearly gerrymandered. It's not unusual in that respect. That happens almost everywhere. The question is whether they're going to be able to convince Justice Kennedy, who has sided with the liberals on the possibility that there might actually be a standard that one could apply. He hasn't seen it yet, mind you, but he's keeping hope alive. Okay, so he has insisted that the question is judiciable, which means the courts can look at it, but he hasn't actually ever seen a standard that he likes. So there was a wonderful competition a few years back where there was this cash award for people who could try to come up with new standards, just to sort of see what might lie out there, what might be convincing. And an interesting professor at the University of Chicago, Nick Stephanopoulos, and some friends worked on this, and they proposed one of them, and they've gotten the federal courts in Wisconsin to accept it. Now that's on its way to the Supreme Court. It is probably the case to watch. But in truth, it depends upon whether Justice Kennedy will now be convinced, and two, maybe what Justice Gorsuch will think about it. I don't think people have a lot of hope there, but it's still in some ways a blank slate. Might be possible.
What was Nick Stephanopoulos' standard, and how much money did he get for it?
Well, actually, I think Nick, worked on this stuff. I can't remember if he actually developed it or was the judge for this whole thing. He's the one who sort of operationalized it and taken it to the courts. But it's a complicated but still intuitively straightforward measure of the kind of discrepancy you were talking about between the popular vote, but it's more nuanced than that, and what you see in the state houses or congressional districts.
Thanks for that, Laura.
So historical context here. First of all, I'm from North Carolina. I feel your pain.
By the way, I should have mentioned there's 32 out of 100.
Yeah. But if it's any consolation, this has been a key issue in U.S. history since its inception. Virginia, North Carolina, South Carolina were known to actually have apportionment that very much weighted the eastern sides of the state, slaveholders, slaveholding areas, and then underrepresented other areas of the state. This has been recurring. It was recurring in constitutional conventions throughout the 19th century into the 20th century. What is interesting, though, is I think this gives a sense of why law is so important. In the 19th century, you were underrepresented. There's nothing you can do about it. With the result of the Reconstruction Amendments, in fact, this is a legal issue now. There are ways that you can actually challenge this in courts of law, and you can claim rights to representation. So it seems dire, but on the other hand, if it's any consolation, in the 1830s, it would have been worse. There wouldn't be a lot you can do.
What a cheerful slogan. That's
right.
really just great. I think we...
There you go. But at least there is a legal way to challenge this now, which I think is very interesting and says a lot about the power of law.
2017, not as bad as 1843. It's
Indeed.
really, really great. I think we have time for one more question. If there is one. Yes, please.
Yeah. Just wondered what your prognosis is for some of the religion cases that will be coming down that could call into question perhaps the same-sex marriage decisions or other cases that implicate 14th Amendment values.
Judge, you may not want to prognosticate, but do you feel able to say anything about the trends in First Amendment religious liberty jurisprudence?
Well, it'd be kind of difficult because we heard a prayer case, legislative prayer case en banc, and not too long ago, and it's still within the breast of the court. And so I wouldn't want to comment on that in terms of trending and where it might be on that.
Anyone able to speak?
I mean, I have no real expertise here. This is just predicting, the judicial future. But I'd be surprised if the Supreme Court had a real appetite at this point to roll back the same-sex marriage cases, at least without a few more appointments. On the other hand, I believe that to some, not to everyone, but to some people, the particular religious equality cases, I think you're thinking about the ones making exceptions to certain otherwise across the board rules, are viewed as a kind of, what's the best way, a kind of stalking horse for the same-sex marriage cases and a lot of issues about sexuality, maybe gender equality and some other things. And so it may be tempting for some people on the court to actually, to try to sort of keep things into equilibrium. If you go in the sort of pro same-sex marriage direction, that it is at the same time very important to recognize some people's concerns with that and to go in the other direction as well. But of course, in the end, what that does is produce a more divisive culture, which we all live in. It would be interesting to see whether that actually settles any disputes or actually encourages more in the long run.
Well, this has been a remarkable panel, and I think that we have learned that the promise of the 14th Amendment, based on the demands of the freedmen and the natural law visions of the abolitionist, was a dialogue. And we've learned about the conversation between the courts and the political branches, sometimes ebbing, sometimes flowing, but always in the process of defining this most central of all amendments. I'm so grateful to Linda Klein for having summoned this program, and please thank our panelists and Linda for having convened this phenomenal panel.
Wow. Wow. This concludes our panel discussion on the 14th Amendment, and a special thank you to our moderator, Jeffrey Rosen, and our terrific panelists. Incredible insight, incredibly thoughtful discussion. Let's give them one more round of applause. Thank you. I would also like to thank our President-elect Hillary Bass for joining us tonight, our Executive Director Jack Rives, and of course our audience here, our live audience, for your participation and for taking the time to join us on this program. The audience out there in video land, thank you also for being there. A special thank you to Stephanie Parker and to Jones Day for hosting us this evening. Have a great evening. Thank you.